Persons and family relations is a 5-unit subject that you will encounter during your first week, probably your first day in law school. It is divided into 2 parts, persons, which covers the first part of the civil code, and family relations, which in turn is covered by the family code. Persons, along with obligations and contracts, are the 2 civil law subjects covered in your first year of law school. They are offered first, precisely because they lay down the foundation of civil law. Once you know persons plus obligations, you will have an excellent platform for a high level of performance for civil law subjects such as sales and lease, transportation and public utilities law, torts and damages, credit transactions, among others. Hindi ako nabiyayaan ng magandang pundasyon sa persons and family relations, kapatid. Kaya hayaan mong simulan ko ito sa isang babala. Mga bata, huwag tularan. Ang professor ko sa persons, pumasok siya noong first meeting. Nag-iwan ng syllabus at nag-discuss lang ng konti. Hiniram niya ang caudal ko, yung maliit na itim na libro na naglalaman ng batas ng civil code, kasama ang family relations. Tinignan niya to saglit at siya namang kanyang iwinawagayway habang itinuturo sa amin ang mga sumusunod. Ang bungad ng persons and family relations ay may matinding overlap sa mga topics na madidiscuss sa statutory construction. Seryosohin daw namin ang basa at aral sa StatCon. Pangalawa, ang bungad ng persons ay isa sa mga pinakamahalagang dapat matutunan sa law school. Gagamitin ito hanggang 4th year. Number 3, kapag bumagsak ka ng persons ay huwag ka na daw mag-abogado. Umuwi ka na lang ng probinsya, magtanim ng kamote at baka mapaunlad mo pa ang pamilya mo. Pagkatapos niya ay umalis na siya, mabilisan lang, kapatid. At sa sobrang hiya at halong takot ko bilang freshman, bilang first year sa first week at sa first day ng law school, hindi ko na nakuha yung caudal ko. Dinala na ni ma'am. Sunod namin siyang nakita ay meeting before midterms na. Pagkatapos ng greeting at prayer, siya namang itinanong niya kung kanino daw yung caudal na hawak niya. At yan, kapatid, ang kwento ng prodigal caudal. It was once, was lost, and then it came back to me. Our professor did not come to see us for almost 2 months. I had mixed feelings on the matter. Ang black namin ay nagbubunyi ay ligtas daw kami sa kanyang torture. Wala kaming assignment, aral lang daw. At the same time, ang aking murang isipan ay natatakot na kung hindi ko maitatawid ang persons, ay baka nga hindi ako karapat-dapat na maging abogado. Pero paano ko naman maitatawid ito kung hindi ko naman alam ano ang babasahin? I did the next best thing, kapatid, and I went to our law library and asked for a copy of the syllabus of one of the scariest professors for persons and family relations. I got my copy and found all of the cases listed in the syllabus. I reached out to someone who was taking her class. Sumunod ako sa cases nila, sa mga reading assignments nila. Sinunod ko ang mga dapat i-digest na kaso na akala mo ay kaklasiko sila. I did all of the work for persons because I was afraid to fail. And I was afraid to have no foundation in the months and years ahead. The following are my notes on persons. Coming right up! Hi, my name is Lex and welcome to Lex in Motion. In this channel, I'll be helping you build your competence, confidence, and capability in law school. Start today by hitting the subscribe button below. New episodes are posted every Friday. Article 2 of the Civil Code provides that laws shall take effect after 15 days following the completion of their publication, either in the official gazette or in a newspaper of general circulation in the Philippines, unless it is otherwise provided. Sa aking murang isipan bilang first year sa kanyang first week sa law school, ang aking unang tinanong ay nasaan yung official gazette? Bakit hindi ko siya nakikita, nababasa o nahahawakan? Sa imagination ko kasi, kapatid, isa itong dyaryo na abot dapat sa lahat ng tao. Gayong ito ay nagiging basihan ng mga batas natin sa Pilipinas na ito ay dapat libreng dyaryo sa LRT o kahit man lang sa mga bus terminal. However, I was wrong. The official gazette contains more than just laws. It is the official publication of the Republic of the Philippines, and it contains laws, issuances, rules, and reports from the government to its people. There is an online version, and I'll be leaving a link to that in the description down below. From the express wording of Article 2 of the Civil Code, alam natin kapatid na ang mga batas ay nagkakaroon lamang ng bisa kung ito ay nailathala, nagkaroon ng publication at kung ito ay na-publish sa official gazette or a newspaper of general circulation in the Philippines. Why is there a publication requirement for laws to be effective? The answer, kapatid, is in the next provision. Article 3 of the Civil Code provides that ignorance of the law excuses no one from compliance therewith. This means that once a law is published, it is conclusively presumed that everyone knows about it and the government to a certain extent expects that we must abide by it. This rule has certain exceptions, but the reason for the publication is it's part of due process. Due process is a very broad concept you will encounter in constitutional law, statutory construction, and labor. Entire books have been written on the concept, and I'll try to explain it later. For now, ang dapat mo munang tandaan ay ang mga sumusunod. Number 1, laws have to be published to satisfy due process requirements. 2, laws require publication before they can become effective. Number 3, once a law becomes effective, everyone must obey the law. The rule that laws must be published before they can become effective was laid down by the Supreme Court in the case of Tañada versus Tovera. Sometime in the mid-80s, Lorenzo Tañada, who later on became a senator, came to court with a group of lawyers called Mabini. They claimed that they have a long list of presidential decrees, essentially laws and declarations made by the late President Ferdinand Marcos. During this time, Marcos had the power to issue laws. They argued that they had the right to know about these laws, that these decrees should be published before they can become effective. The Office of the Solicitor General, essentially the law firm that represents the Republic of the Philippines, argued that Tañada and his group, Mabini, did not have the legal standing to sue. Legal standing, kapatid, is another broad concept you will later learn. At its essence, the rule says that those who come to court must have some interest or some right that is directly affected, could be affected, or immediately threatened by another person's action. The government's position in this case is that the case should be dismissed because Tañada is not affected by the presidential decrees and therefore it is a waste of time to hear him out. The second argument from the government, which I think is even more important, is that the wording of Article 2 provides unless it is otherwise provided. Kung ang mismong presidential decree ang naglalatag kung kailan at paano siya magiging effective, if the law itself provides for its own means and methods of effectivity, then it should not be declared invalid. They argued na ito ay dapat pumasok sa unless it is otherwise provided. We have provided, provided, and therefore these presidential decrees should remain valid. Batay sa panig ng dalawang grupo, ganito naman ang sagot ng Supreme Court. The publication of all presidential issuances of a public nature or of general applicability is mandated by law. Obviously, presidential decrees that provide for fines, forfeitures, or penalties for their violation or otherwise impose a burden for the people such as tax and revenue measures fall within this category. Other presidential issuances which apply only to particular persons or class of persons such as administrative and executive orders need not be published on the assumption that they have been circularized to all concerned. It is needless to add that the publication of presidential issuances of a public nature or of general applicability is a requirement of due process. It is a rule of law that before a person may be bound by law, he must first be officially and specifically informed of its contents. If there is one thing kapatid you should take home from the case of Tañada versus Tovera, it is this. The clause unless it is otherwise provided refers to the date of effectivity and not to the requirement of publication itself, which cannot in any event be omitted. This clause does not mean that the legislator may make the law effective immediately upon approval or on any other date without its previous publication. When do laws become effective? There are three possible answers here. The first one is whenever the law provides. For example, the train law took effect on January 1, 2018, but it was signed into law on December 19, 2017. But because of the express provision of Section 87 of the train law, it shall begin to take effect on January 1, 2018. What if the law itself does not provide for its effectivity? Kung walang nakasulat na effectivity date, and this is our second scenario, then we must apply Article 2 of the Civil Code. This provision tells us that laws take effect 15 days following their publication in the official gazette or a newspaper of general circulation. If for whatever reason hindi na isulat ng Congress ang Section 87 of Republic Act No. 10963 or the train law, then we will count 15 days from the date of publication. Assuming na pinirmahan yan ng Pangulo ng December 19, 2017 and it was published on the next day, December 20, 2017. Kukunin natin yung date of publication, ang petsa kung kailan siya nailimbag at magdaragdag lang tayo ng 15 days. Why? Because Article 2 of the Civil Code provides that laws take effect after 15 days following the completion of their publication, either in the official gazette or in a newspaper of general circulation in the Philippines unless it is otherwise provided. There is a third scenario at bihirang-bihira na ganito pa ang phrasing ng effectivity clause or that part of the law that provides for when a law will take effect. And that phrase is shall take effect immediately upon its approval. Now, kung sinulat ng Congress sa Section 87 ng train law, shall take effect immediately upon its approval, anong ibig sabihin yan, kapatid? Ibig bang sabihin ay sa araw mismo na ito ay mapirmahan, game na? Bababa na ba ang ating buwis at liliit na ba ang mga serving sizes sa fast food chains? There are actually two views on this matter. The first view is taken from the case of Fariñas versus Executive Secretary. In this case, Congressman Rodolfo Fariñas and then Congressman Chis Escudero, along with other members of the House of Representatives, came to court to challenge the constitutionality or validity of Republic Act No. 9006 or the Fair Elections Act. They claim that Section 14 of the Fair Elections Act repeals or essentially deletes Section 67 of the Omnibus Election Code. Section 67 provides that incumbent elected officials, except the President and the Vice President, are deemed to have resigned their positions upon their filing of certificates of candidacies for other positions. Sa unang tingin, kapatid, maganda yung rule dahil kung sa paghabol ni Mayor sa ibang pwesto gaya ng congressman, automatic na siyang magre-resign kapag tumakbo siya. Hindi na niya magagamit ang mga resources ng office niya para mangandidato. Sa Fair Elections Act, inaalis yung rule na yan. Meron sigurong gustong makinabang dito. Now, the way the majority of Congress wanted to do it is by smuggling this provision inside another law, the Fair Elections Act. The minority raises two arguments. Number one, the Fair Elections Act is unconstitutional because it violates Section 26, Paragraph 1 of Article 6 of the 1987 Constitution. This contains the rule that all laws should only have one subject and that subject should be included in its title. Number two, the Fair Elections Act is invalid because its effectivity clause provides that it shall take effect immediately upon its approval. The majority responded that the minority did not have the legal standing to sue. They did not have rights that were immediately affected or threatened with the passing of the Fair Elections Act. The Supreme Court ruled that some sectors of society and in government may believe that the repeal of Section 67 is bad policy, as it would encourage political adventurism. But policy matters are not the concern of the court. The repeal of Section 67 is valid because the petitioners, the congressmen who came to court, were already aware of that provision. They may have voted for or against it, but they voted on it just the same. It is not a rider or a piece of the law that was smuggled in. Pasok sa konsepto ng fair elections ang provision na nag-aalis ng discrimination, positive man yan o negative discrimination. Second, then-President Gloria Macapagal Arroyo signed Republic Act No. 9006 into law on February 12, 2001. This law provides that it shall take effect immediately upon its approval. The Supreme Court ruled that this phrase is defective, but it does not render the entire law to be invalid. Publication is indispensable in every case, but the legislature may, in its discretion, provide that the usual 15-day period can be shortened or extended. In the case of Republic Act No. 9006, the phrase "shall take effect immediately upon its approval" should be taken to mean 15 days after its publication. That is the first view. The second view, which I think is the more correct view, was first laid down by the Supreme Court in Labugal-Bilaan Tribal Association Incorporated versus Secretary Victor Ramos. In this case, a group of indigenous peoples came to court to assert their rights to their ancestral land. It's a very interesting case, kapatid, and there are a lot of concepts that the Supreme Court teaches us. It's an important case for freshmen because it touches on topics across constitutional law, environmental law, a little on property, and of course, statutory construction. I suggest you read it at your own time, kapatid, and I'll be leaving a link to that in the description down below. In this case, the Supreme Court ruled that when the law states it shall take effect immediately upon approval, it becomes effective immediately upon the publication. What is mandatory, the Supreme Court emphasized, and what due process should be about is that the law must first be published in the official gazette or a newspaper of general circulation. To summarize our rules, number 1, a law becomes effective on the date it so provides. Number 2, if the law does not state a date, we take the date of publication and count 15 days after the publication date. Number 3, if the law provides that it shall take effect immediately upon approval, it becomes effective on the date of publication. The basis is the case of Labugal-Bilaan Tribal Association. When the law mentions a newspaper of general circulation, what does that mean, kapatid? Anong klaseng dyaryo ito? If the law has national coverage, meaning it covers everyone in all places all over the country, then you're looking at our broadsheets. If it's provincial, you have your provincial newspapers. If it's a municipal or city ordinance, then that includes your local newspapers. Kung ikaw, kapatid, ay magbubukas ng iyong sariling law office pagdating ng araw, magugulat ka na lang na maraming mga ahente ang lalapit sa iyo. Naroon yung mga gumagawa ng calling card, website, sa telephone directory at iba pa. Kasama sa kanila ang mga ahente ng mga lokal na dyaryo. Nakaramihan sa kanila ay hindi mo pa nahahawakan o manababasa man lang. Mahal ang konting space sa print media, kaya marami ang mga nagsusulputang mga maliliit na dyaryo na lokal. Sila ang yung mga magiging kaibigan whenever you need something published. Elsewhere in the civil code, like in succession and property, whenever the law requires publication, sila ang makakatulong sa iyo. I think we can stop here, kapatid, but there are 2 more points I want to make before we end. Una, a big thank you to everyone who has responded to the survey over the weekend. Napakalaking tulong ng iyong sagot, kapatid. In case you want to join the survey, there will be a link to that in the description down below. Second, if you would like to see more of this kind of content in our future episodes and in other subjects, please type yes in the comments down below. Finally, there is a short quiz. Akala mo ba lusot ka na, kapatid? And if you would like to test your understanding of the material, challenge yourself, kapatid, and your potential ability to perform in law school. Then comment your score below. Please do not copy and paste the questions at baka may mangopya pa. Thank you so much for watching. Like and share this video for good law school karma, and I will see you next Friday.